In tonight's edition, New South Wales closes Pathway 1 and opens Pathway 2 of its 491 visa sponsorship program. An update on the invitations issued for both the 190 and 491 visas. Donald Trump envies Australian citizenship changes of 1986. Putting an end to the rumours about Condition 8579 for the 491 visa. And looking at Condition 8607 of the 482 visa. The biggest news to share tonight is that the channel has now more than 100,000 subscribers. What a milestone to reach, and I never dreamt that we would get there so fast. So I'd like to thank all of you who have made that possible. So many of you have given that continued support in your comments, and those who I have met during consultations also. You are the very reason why I keep going. That silver button YouTube Creator Award should arrive in the next few weeks, and of course it will be here on the desk to share with you all. The next milestone is the 1 million gold button, so let's get on with it, shall we, for this week's episode. The New South Wales Government announced yesterday afternoon that the 491 visa state nomination Pathway 1 is now closed. Applications already lodged will continue to be finalised, but they say an extended processing time of about 6 weeks can be expected. If you have already lodged your application but have an urgent request, such as your visa is about to expire, please contact them directly and let them know. They have also announced that invitations will now be sent out for Pathway 2 of their 491 sponsorship program, so make sure your EOI is accurate and current. Good luck to everyone who has an EOI in for New South Wales. The Immigration Department has updated the latest figures on invitations for the 190 and 491 visa programs broken down state by state. From the department's website information, we have made this table to compare the quotas allocated to the states and territories for both visa subclasses and the number of invitations issued so far. You will notice that Western Australia has a minimal number of invitations issued compared to their quota, but that does not match the WA website, where they say that more than 7,000 invitations were issued. However, remember that invitations do not mean the number of people that actually end up applying. The problems with issuing invitations to prospective applicants based on EOIs only to apply for their state means that in general it seems only about half end up actually applying for state approval. Since these figures are up to date to the end of December, we can only assume that not all the applicants who were invited to apply to WA are represented by these numbers. Also, since we know that the New South Wales Government has a large number of 491 Pathway 1 applicants yet to be processed, the 392 people quoted on the department's table will rise quickly in the next month or so. Stay tuned for the next update. Most of you have probably already heard that the President of the United States, Donald Trump, is trying to copy Australian citizenship laws. Back in 1986, Australia stopped children from obtaining citizenship simply because they were born here. So why is Trump already striking trouble when Australia quickly changed their laws?
We have more breaking news to kick off this hour of The Will Cain Show. This afternoon, a federal judge temporarily blocking President Trump's executive order on birthright citizenship, calling it blatantly unconstitutional.
Australia successfully made the change because when the Constitution was written here back in 1901, there was a deliberate decision to leave the issue of birthrights out of it. This enabled successive governments to make laws about who can stay in Australia without the worry of lawsuits citing constitutional objections. This gives Australia the right to change its citizenship laws as the country evolves and to reflect community expectations. Back in 1986, there were political issues in Australia not so dissimilar to other countries' concerns. At the time in Australia, the Minister for Immigration and Ethnic Affairs justified the change by stating, "A generosity in our law can be exploited by visitors and illegal immigrants who have children born here in order to seek to achieve residence in Australia." However, Australia did leave the door open to children born here to temporary visa holders and unlawfuls, but only if they remained ordinarily resident here for the 10 years after their birth. This was in recognition that many temporary workers in Australia had been here a long time. If their children were born here and spent the first 10 years of their lives considering Australia their home, they have the right to citizenship. Even the term ordinarily resident used in the Citizenship Act gives some flexibility to children who may not have stayed here for all of those 10 years, but the parents have. In Australia, legal cases have established a common law principle of how this ordinarily resident term is interpreted. We have many cases where children were born here but spent some years overseas whilst their parents remained in Australia and still obtained citizenship. In July last year, the government made it easier for 482 visa holders to move around and find that alternative sponsor if necessary. They did this by altering Condition 8607 imposed upon all 482 visa holders. There is still some confusion about this condition, as many viewers have asked similar questions like this. Hi Karl, thanks so much for your videos. Can you please help us explain in detail about 482-8607 visa condition? If your employment with your sponsor ends, you can stop working or work outside the above conditions for a limited time, up to 180 days in a single period, up to 365 days in total across the period your visa is granted for. It's complicated to me to understand this. Well, let's take a look at Part 5 of Condition 8607 in the regulations. The holder may cease work in accordance with Subclause 1 and 2 for a period, but A. Any such period must not exceed 180 consecutive days, and B. The total number of days on which the holder does not work in accordance with Subclauses 1 and 2 must not exceed 360 days during the visa period for the holder's visa. So if you leave your sponsor in employment, and it doesn't really matter why, you have a maximum period of 180 days in one go to find a new sponsor and have a new nomination approved. If your new sponsor does not get approval before that time limit, you will not have permission to work for them once the 180 days expires. Normally, as long as that new nomination has been lodged with the new employer and you are waiting for the decision, the department will not take steps to cancel your visa, and you can wait until the nomination is approved. If the nomination is refused, the department may take steps to cancel your visa. Alternatively, if you have not found a new sponsor in this 180 days, you could just apply for a new visa, such as a student visa or visitor visa. Alternatively, the 180 days could also be used as a 6-month holiday before you go home. Quit your job 6 months before your visa expires, and off you go. Have a great Australian adventure. Now, Condition 8579 is attached to all 491 visa holders and is probably the most discussed and misunderstood visa condition out there. And the reason is because it is very important to go on to that next stage of getting PR. Those who fail to comply with conditions on their 491 visa have the chance of having their permanent residency via the 191 visa subclass refused. I have made videos about this condition before, but let's cover some of the issues that keep popping up in the comments section. Hi Karl, can you do a video for 491 state change, since people are saying that moving to another state from the nominated state will affect on citizenship? From the Northern Territory, we want to move to another state. Most people know by now that moving between designated regional areas, known as DRAs, is entirely acceptable. When you come to lodge your PR visa later, they will not even ask you why you moved out from your original DRA. However, this citizenship rumour is still making the rounds. Moving from one RDA to another has no impact upon citizenship applications. Only serious character concerns can stop people from obtaining citizenship, and RDA hopping certainly does not fall under that category. So, end of rumour. Full stop. The next rumour to put an end to is this: can't be outside of an RDA for more than 90 days. As Amaral writes in and says, "Hey Karl, thanks for your efforts to deliver the right information to us. Most of the migration agents scare people." Recently, there has been a refusal letter circulating on all online platforms like Facebook and TikTok, in which it mentions that 191 visa has been refused because the applicant was absent for 192 days from Australia, which had breached the conditions of residency requirement that an applicant must not be absent from Australia for more than 60 consecutive days or 90 days in total per annum. Do you have any information regarding this? Please help us digging into this residency requirement for the 191. Every one of us is very scared because nowhere on DOA's website it mentions anything about this issue. Please help us digging into this matter. Let's begin by making it 100% clear there is no residency requirement in the regional stream of the 191 visa, and that's why the Immigration Department does not mention it on their website. This 90-day issue has been completely taken out of context by less experienced advisors reading the Immigration Department's Procedural Advice Manual Guidelines on Condition 8579, particularly Section 3.2.8, labelled Time Spent Outside of a Designated Regional Area. In this section of the policy, it says, Condition 8579 is not intended to prevent a visa holder from engaging in incidental activities outside a DRA. Such activities may include holidays, work-related travel, and work-related training. It is intended to adopt a flexible approach to the assessment of compliance with Condition 8579, taking account of the personal circumstances affecting individual visa holders. Okay, fair enough, no issues there, but it is this next part that creates confusion. However, extended absences from the DRA will require scrutiny to ensure that the visa holder is or was living, working and studying in the DRA during the relevant periods. Under policy, further information should be sought from the visa holder on the reason for travel outside the DRA, where the holder spends more than 90 days in total per annum outside the DRA, or the holder spends more than 60 continuous days outside the DRA, or there is a pattern of extended and or frequent absences that are indicative of employment outside the DRA. Now, people read this part and panic and say, oh, I can't spend more than 90 days outside of Australia in 1 year. So calm down and take a deep breath. You have to take the Condition 8579 regulation literally for what it says. The wording of the regulation states, 1. If the visa is a subclass 491 skilled work regional provisional visa, the holder, while in Australia, must live, work and study only in a part of Australia that was a designated regional area at the time the visa was granted. This previous policy section I just read out to you, section 3.2.8, is about people who are already in Australia. It does not refer to those who have spent time outside of Australia. And the policy a little earlier in PAMS 3.2.2 makes that clearer, for it states, Condition 8579 provides that while in Australia, subclass 491 holders must live, work and study only in a part of Australia that was a DRA at the time the visa was granted. It is absolutely crystal clear. While in Australia, 491 visa holders must da-da-da-da. The condition only applies while the holder is in Australia. You can spend as much time outside of Australia as you like, and there is no impact upon Condition 8579. But when you are in Australia, you must comply with it. Spending time outside of Australia cannot impact a 191 visa application in the regional stream, because that stream is about meeting your visa conditions and giving evidence of tax returns. We have clients who have spent significant time outside of Australia and have already been granted their 191 visas, no questions asked. So an end to that rumour, but for more information on meeting the 191 visa requirements, please check out our special video on that topic. And it shows you should never pay attention to fake documents flying around on social media. Well, another busy week has passed in the world of Australian immigration. Also thanks to Constantine, who does a fantastic editing job on our videos to help us reach that 100,000 subscriber mark. And also thanks to Zoe in the office, who checks the legal aspects of my scripts. And of course, I can't forget to say thanks to my wife, who spends hours researching for new stories every week, checks my scripts, and keeps me under control, so I don't sound like a raving old lunatic. Until next week, take care out there, and I will see you next time. So bye for now.